learned President of the Supreme Court Bar Association to deliver his speech.
My Lord, the Chief Justice of India, Shri Sanjeev Khanna, Honorable Judges of the Supreme Court of India, my friend, the Attorney General, the Solicitor General, law officers, Executive Committee members of SCBA, the President of the SCORA, Executive Committee members of SCORA, my colleagues present here. As we gather here today to reflect on 75 years of this great institution, I want to begin by paying homage to those who brought us freedom. We pay tribute to the sacrifices made by millions who resolved to fight the might of the empire with the weapon of nonviolence. Used for the first time in any freedom struggle, this weapon signified a moral authority more powerful than the threats, violence, the criminal dehumanizing acts our people were subjected to. It is this hard-won free independence and this defiant allegiance to democracy that this court has been tasked with protecting, bringing dignity, autonomy, and mutual respect to the everyday lives of ordinary people. Right since its inception, our court has had no hesitation in deciding cases as per law without undue favor to the all-powerful state and with no regard to the political popularity of the policies in question. It was this independence that had the court questioning by 1964 whether the government had unlimited powers to amend the constitution to take away fundamental rights in Sajjan Singh's case. In 1967, to protect individual liberties, the court held that the government had no power to amend fundamental rights in the landmark judgment in Golaknath, refusing to accept the argument that if the government was stopped from amending fundamental rights, there would be chaos. Finally, the impasse ended with the Supreme Court propounding the famous basic structure theory that disallowed amendments to the basic features of the Constitution in case of Nand Bharti. Faced with blowback in the form of judicial supersession and unprecedented transfers impacting the independence of the judiciary, and in time judicial review, the court in S.P. Gupta and later in Supreme Court Advocates and Record Association evolved the collegium system to protect the judiciary from the executive. In Bomai, the court came down heavily on the abuse of 356 to dismiss state governments for political reasons. In Vadhva and Krishan Kumar Singh, the court struck down repeated ordinances to bypass lawmaking to be a fraud on the constitution. In essence, the court has been responsive to the needs of the political environment and has sought to best preserve the constitutional vision of our founders despite the continual stresses and strain in our chaotic democracy. An area where the court has left an indelible mark is in the area of fundamental rights and civil liberties. The difference between A.K. Gopalan on the one hand and R.C. Cooper and Maneka Gandhi on the other, or between M.P. Sharma and Puttaswamy, Swamurthy Vishnu Joseph Shine, Suresh Kumar and Kaushal to Navtej Johar, Champaran Dorerajan to Indira Sani, or Anwar Ali Sarkar to E.P. Royappa is one born of a deeper understanding of fundamental rights, what they mean, how they relate to each other, and how they empower citizens. In this journey, the court has relaxed the requirements for legal standing to enable public interest litigation by public-spirited persons to bring to light injustices suffered by the powerless or deal with large-scale problems like bonded labor or the environment. The Supreme Court has developed an enviable jurisdiction on fairness in administrative action using doctrines such as promissory estoppel, Motilal Padampat, proportionality, modern dental, manifest arbitrariness, Shaira Bano, and the principles of natural justice, Indo-Afghan agencies, etc. Its curative positions have opened a jurisdiction to correct errors quite unknown to the rest of the world. In 75 years, we have seen many great judges and chief justices, Justice Mukherjee, Justice Bose, Justice Subbarao, Justice Hidayatullah, Justice Krishna Iyer, Justice Venkachalaya, and many others. There can be no better example of judicial independence and courage than H.R. Khanna. They have been trailblazers and a model to follow. This is not to say that the court has not on occasion erred. The infamous Jabalpur, ADM Jabalpur judgment where this court did not heed the wisdom of the high courts and ended all constitutional means to combat the emergency is an indelible stain. There are cases where the court should have intervened and did not. or where it has intervened in matters where it lacks both institutional competence and legitimacy. The question remains and to be asked, does the court retain the elements of what has made it so great in the past? Will the court continue to be an indispensable institution in our democracy? I am confident that it will, if it avoids certain pitfalls. First, the court must find a way to solve the enormous backlog. Second, the court's strength lies in the principles of open justice, where the most persuasive argument ought to prevail, and the power of argument must prevail over the argument of power. This means that the judiciary must eschew excessive secrecy and embrace a more open way of being. Third, the court must find a way to ensure that polyvocality, 15 different courtrooms, do not become 15 independent courts. Stare decisis and judicial consistency are the embodiment of the rule of law. Fourth, the court must not forget that the primary quality of predecessor judges who are remembered in their courage to defy conventional wisdom, to follow the untrodden path, to do the right thing. Courage is contagious, but so is cowardice. Our Constitution and its own proud history both demand that the court always stand up for our values, our freedoms, and our hallowed democracy. Our Constitution is at once accessible and sublime. Its message is loud and clear in the heart of all patriots. When we look at the history of independent India as outsiders or historians, we note that when faced with difficult odds, the Constitution has found its unassuming champions, not in the least among the bar and on the bench of this august court. This Bible of ours instills in us the values that we need to cherish, the values of sovereignty, of protecting the security of the state, of ensuring that our freedoms are not trampled upon, as this republic, through its democratic processes, seeks to realize the aspirations of ordinary folk at the bottom of the ladder. While the republic has done human service to us in the past, we need to remain vigilant. This court must be the champion of our Constitution and bring to life the values of constitutional morality hidden within the cold print of the articles of the Constitution. These are interpreted by our great judges who truly understood, when confronted with challenges, the meaning of the constitutional values that permeate each article of the Constitution. These values need to be preserved, and we, the members of the bar and the judges, owe our allegiance to the rule of law, the upholding of which is our solemn responsibility.
My esteemed brother and sister judges,